thing. And so probate became the word that was used for going to court to prove someone's will. And there are, generally speaking, three types of situations where an estate will have to be brought to probate. And that is where you need a court order to confirm the authority of the person who's named as the executor or the estate trustee. And when I use the term executor or estate trustee, they're interchangeable. They mean the same thing, the person appointed to administer the affairs of the deceased. So usually you go to court to confirm the authority of the estate trustee because third parties holding the assets of the deceased insist upon it. I'm going to come back to that one in just a moment because it's the major situation under which we apply for probate, as it used to be called. The second situation, though, is where we need an estate trustee or an executor to be appointed because there isn't one. And that happens in situations where I die without a will. So because I've died without a will, the law does not provide any default mechanism by which somebody is automatically appointed as my estate trustee or my executor. If I die without a will, it means that usually my family has to step forward and ask the court to appoint them or one of them to be the estate trustee. So that's the second situation where there isn't an executor or estate trustee. The third situation is always the juiciest. People love hearing about this one, but my impression is that it only really represents probably under 5% of all cases where probate's applied for. And that's where there's a battle over the will, whether the last will is valid, whether there was undue influence, whether there was duress, whether there's another will, whether there's a forgery. In those cases, the probate process is still used to prove whatever document is in hand after death. So there's the three areas. Number one, where there is a will, application is made because parties holding the assets of the deceased want it. Number two, where there isn't a will, there's not an estate trustee or executor appointed, and so you have to go to court and ask the court to appoint one. Or the third one is that juicy one I referred to just a moment ago, where there is doubts being cast about the validity of the will that's being put forward. Okay, let me deal with the main one, and that is that situation where third parties have asked for, and that's okay, Katie, go right ahead to the next one.
Okay.
Yep, we're going to flow right into it.
Okay.
Why third parties ask for probate. And I'm just going to pause. This probably won't be the visual that I had intended, but what probate is in the final analysis is not even referred to as really probate anymore. It's called a certificate of appointment of a state trustee. A state trustee meaning executor, executrix, and so on. And it's a piece of paper. This one's blacked out to protect those named in it. But you'll see it's a court order. And the will is attached to it. And the essence of this court order in most instances says, in the matter of the estate of so-and-so who died on such and such a date, here is who has been appointed to be the estate trustee or the executor. Court seal, signature, will, a copy of the will attached, and away you go. Well, why do you have to get that? A will operates, a valid will, assuming there's no fraud, forgery, duress, and so on, operates from the moment of my death in any event. Why do you have to get probate? The will is perfectly valid. And that's absolutely correct. But I'm going to get back to these third parties. And what do I mean by third parties? Typically, I mean financial institutions, the land titles office, and some other institutions who hold the title to the assets of the deceased, who say to the executor, we're not going to give them to you until you get probate. Why do they say that? Well, they say it because there's an old rule around that says if a financial institution, I'll use that as my example, turns over the GICs and savings and other investments of the deceased to somebody who's presented the will, is well known to them, and may not even be a fraud artist, turns it over, and it turns out that that will is not the last will of the person, then the holder of those assets, turn the assets over, is liable to pay twice. As a general rule, none of us like to pay twice, but specifically if you're a financial institution, you don't want to pay twice. You don't want to give assets to somebody, everybody's acting in good faith, you give them, they're distributed to beneficiaries, money spent, all the rest of it, and it turns out it wasn't the right will. So probate's the way to get the court order that says this is the right will and this is the person who is administering it. So why do people hate probate? Well, number one, lots of work, and it is a lot of work, because in order to obtain probate, either at the time you're making the application or at least over the course of time while the application is in process and the certificate's been issued, you have to make careful inventories of the assets and the liabilities of the deceased, and you have to do it quickly. In most instances, the applications for probate are filed after you have a good idea, and usually confirmation in writing from financial institutions about the value of assets. And by the way, assets include homes, they include money rights, interest things. So it's lots of work. The second reason is because we have something in Ontario called the estate administration tax, sometimes called probate tax, and that's not a real term, but estate administration tax is sometimes by some people called probate tax. It is only payable upon filing of the application for probate with court. So if you don't have to apply for probate, you generally speaking don't have to pay estate administration tax. And that tax, there's a formula, there's a great little calculator to use, and I always use it rather than use my fingers and try to mess around with the calculator. But for those estates of value over $50,000, you're looking at upwards of 1.5% of the value of the assets of the estate. If the value of the estate is under $50,000, there's no estate administration tax charged anymore. So lots of work. You got to hurry up, try to figure out where all the assets are, get confirmation of what their values are, because you need that for your application. You know you're going to pay this as estate administration tax as well as the court filing fees when you apply, and you're probably going to need a lawyer. Now, I've never understood people's reluctance on this issue. I mean, lawyers have families, we have to live, we're part of the economy, but for some reason people, it's a little bit like taxes. There's a reluctance to have to pay, or at least there's a feeling of, why do we have to pay a lawyer to do this when the deceased worked so hard and we just want to administer the estate? Typically, my recommendation to people is that unless you have an estate that's extremely well documented and easy to move forward with, you should consult with a lawyer at some point in time in most instances of an estate. What's the fourth reason? Well, we're coming to this. It comes really from 1, 2, and 3, and that is it takes time and delays estate administration. Why? Well, remember I said that the financial institutions, so with apologies to all the bankers attending today's webinar, if the bank is holding certain kinds of assets, like a GIC, like money in a bank account, and I'm going to use the example of over $50,000, and the bank says we need this probate, they're not going to let the executor, much less the beneficiaries, have that money. Now, they'll probably make arrangements to make sure that some bills are paid. Banks are quite good at that, but it just delays everything. It takes time, delays estate administration. And number 5 is really important if you're going to be an executor for somebody, an estate trustee. Time plus money and the calls from the beneficiaries. Now, I want to be very clear. Being a beneficiary is a wonderful thing. It's a wonderful thing. And certainly for those of you considering me, I'm happy to be your beneficiary, as they say. But the fact of the matter is that beneficiaries usually don't appreciate the time it takes and the work going through this whole process. And so they just get real frustrated because, hey, it's our money. Give me what either was left by the deceased in a specific gift, or alternatively, if I'm getting a share of the residue of the estate, just give me the money. Let's get going here. Beneficiaries don't always understand that. So that's why people hate probate. We'll go on to the next slide. Recently in the province of Ontario, and recently means April, we've had a stream developed where for estates valued at $150,000 or less, you can apply for probate now through a small estate court process. If the estate's valued at over $150,000, you use the regular process, the usual application for a certificate of appointment of estate trustee. It's a little too early, and I haven't really got the feedback yet from a lot of people involved to say whether this small value estates approach is going to be worthwhile and maybe reduce some of the hate or fear of probate. But it's certainly an important start for those people who have estates that they have to administer and the value is less than $150,000. Katie, we'll go to the next slide. What do you need to apply for probate? Well, this is a rather simple statement here. What you're going to need is the original will. Now, remember, I said that an application for a certificate of appointment of estate trustee without a will is also sometimes referred to as probate, or at least follows a very similar process. So if there's not a will, you're not going to have the original will, obviously. And so the next part of it is that you have to make sure you've got the original will. You then have to make sure you've got any additional documents. Sometimes they're called codicils or addenda to will. And of course, you need proof of death. Quite often those who are dealing with funeral service providers, say in Ontario, the practice here is just that there are funeral directors proof or statements of death that are made available, and they're often filed. And then lastly, it's the court form that requires information about the deceased assets and the beneficiaries. What about the deceased assets? Well, the court needs essentially a statement as to what the value of the assets are. The applicant or the executor and estate trustee has to swear to that value to the best of their knowledge and belief, of course. Why include the beneficiaries in this process? Well, the beneficiaries in this longer form approach have to get notice of the application. So these are the beneficiaries named in the will. If there is a will, they get notice of the application. And so we need proper names, addresses, and all the rest of that good stuff. Thank you, Kate. Yes.
Did your video turn off on purpose?
I don't think so.
Okay.
But we'll find out.
We've lost our visual on you.
Oh, that's a horrible, terrible thing. There, I just turned it off and on, and I think we're okay now.
Thank you.
Thank you. You'll probably get a lot of messages now saying, please ask him to turn it off again. All right, so this is entitled, and by the way, this is entirely my fault. It says, who doesn't need to go through probate? It really should say, what types of assets don't need to go through probate or be considered in the estate? And there usually are the two major types here. Jointly owned with right of survivorship, or financial plans that have a designated beneficiary. Why? Because if there's a jointly owned property with right of survivorship, and I'll get back to explain that in a moment, or there are designated beneficiaries under a financial plan, let's think about insurance and RSPs and that kind of stuff. Indeed, those assets go outside of the estate and go to the surviving joint owner or the designated beneficiary. So they are usually not the assets that are included for the probate purpose. Now, what are jointly owned with right of survivorship? For most of us, they're things like houses, bank accounts, and investments that we may hold with a spouse or a family member. The spousal one is likely the most straightforward. Holding jointly with family members has certainly become popular as well, as people try to avoid probate, or at least minimize the value of the assets. So they put other people's names with theirs on their homes, they put them on investments, they put them on bank accounts, and so on and so forth. All of that's good, except notice the second point. Hint, hint, ask your lawyer or tax advisor about this aspect. I don't want anybody listening today, or alternatively anybody who might be doing this later, to go racing out and just trying to put all their assets into joint ownership, thinking indeed that that's a great way to beat the government. There are some planning techniques, but you have to be awful careful because, for example, the moment you start dealing with title to certain assets, you may trigger an income tax problem. So you may not have an estate administration problem, but you might have an income tax problem because you'll have been deemed to dispose of an interest in your property, especially when it comes to family homes or your principal residence. Be very careful.
Very interesting.
It is the case that we found a lot of people trying self-help. The fact of the matter is that the self-help should be used as the kernel of the idea, and go and see your lawyer, your accountant, your financial advisor, and so on, to walk through what the plan might look like. We're going to come back to this in a moment. But right now, we're going to deal with information about the assets and liabilities of a deceased person. This is a fascinating question for me because I see it all the time. There's no doubt that in our society today, theft of identity, theft of information about assets, not so much with liabilities. They don't want to know about the debts, folks. But theft is real. We do see it happen. You have to be careful in protecting your personal information, specifically when it comes to your finances and so on. But the opposite is not true. The mere fact that they can steal the stuff electronically in particular doesn't mean that there's a central clearinghouse or a manner by which I can press a button and find out all of the most current information, date of death information about the assets and liabilities of a deceased person. Notwithstanding our electronic world, there's still a lot of legwork that goes into finding out what the deceased had as assets and liabilities on the date of death. So what is the reality? The reality is that if you are acting and you know you're going to act as an executor for somebody, an estate trustee for somebody, please ask that person or help that person to list their assets and liabilities. You don't need numbers, but what you really need to know is where to ask. So the mere fact that, for example, there's a bank account at 2 different banks, you need to at least know the name of the banks so that you can inquire there. If there are financial investments with an advisor or otherwise, you need to at least know who to ask. So have the conversation. This is all part of good planning. Have the conversation. List the names of where the assets are kept. You do not have to get into amounts, addresses, phone numbers, or contact numbers. Just know the name of the institution. Same thing with debts. Where's the money owed, so that upon death, the administration of the estate can be done efficiently. And let me say this, our digital world only makes this a tougher conversation to have, because when they ask me about my assets and liabilities, I'm going to have to tell them that, you know what, most of my banking is done online. And guess what the question is going to be from my future estate trustee? It's going to be, what are your passwords? How can we access online and figure this out without your passwords? So don't forget your digital goods. Very important. And again, lots of work. Is there any way around probate if the bank or financial institution holding the assets requires it? The answer is sometimes. Remember that the reason that the bank or financial institution is asking for probate, this proof that this is the will and this is the executor or estate trustee of the estate, is because they don't want to pay twice. And so most financial institutions set a threshold. I'm going to use $50,000. It's up to the individual institution to set this threshold, but usually below that threshold, the bank or financial institution will consider taking what's called an indemnity. What's an indemnity? It's where the executor, and sometimes maybe the beneficiaries, come into the bank and say, look, you've got 48,000 bucks here. Yeah, you either know us or we're prepared to demonstrate that we're people of good character and so on. We will sign an agreement in favor of you, bank or financial institution, that says if you give us the money and it turns out later that you shouldn't have given it to us, then we will pay you back. So it's a promise to repay or indemnify the bank, and that's a way around it. There is, of course, some of the planning techniques that we talked about just a moment ago, and I'm going to talk about that, about how probate can be avoided in just a moment. And for some reason, Katie, there we go. Okay. My screen keeps going black, which may be a hint. Okay. How about paying estate debts before the estate is settled? If the estate has to wait for probate, no executor can walk in and simply start writing checks. It's all about having a meeting with the institution that's holding funds and trying to convince them of the need to make certain payments. As a general rule, the financial institutions, even while we're waiting for probate to be granted, the financial institutions will take care of the ordinary debts, utilities, and so on and so forth. If there's a home involved in particular, they'll take care of final expenses like funerals, cemetery, crematoria costs. Many of them will even pay for a good reception when we come back to having those. And they will speak about the possibilities of using other money. But again, they're going to look to the estate trustee to make sure that that probate is granted, so the bank doesn't end up having paid out money and not have a sound basis upon which it paid out. So another conversation, that's why I said have that conversation with the person you're going to be acting for about not just assets, but about debts as well, so there can be a plan put in place. Talked about probate tax a little bit. And I think the basics we've already gone through, so I'm not going to bore you with it, other than remember, if the estate is $50,000 or less, no estate administration tax. For estates over $50,000, you have to pay estate administration tax. If there's no dough available to do that, you can ask the court for an order that defers the payment of the estate administration tax until the estate is in a position to pay. There's also filings that have to be made under the estate administration tax by the estate trustee after probate has been granted. Thank you. Oh, this is a great question because we get it all the time. Estate administration tax, or probate tax as some refer to it, estate administration tax is not the same as income tax. It is a separate tax imposed. I'm not trying to get them into trouble, but it's imposed by the province of Ontario. Income tax is different. Income tax in Ontario, at least, is federally administered. The main Income Tax Act, of course, is federal. The Ontario government also gets income from income tax. For most people, income tax upon death arises this way. And by the way, I'm giving you a very simplified version of a very complicated area. That's why the Income Tax Act is about that big. The fact of the matter is that when one dies, any money in the bank upon which tax has already been paid is not going to be subject to tax. Why? You've already paid the tax. So there might be some interest that's accrued. Otherwise, you have to look at things like capital gains tax. You have to look at things like RSPs if they're not being rolled over to a spouse, and so on, which can be a little expensive. So please get some advice there, because the state administration tax at 1.5% I mentioned, nothing to do with income tax. And we'll go to the next slide. How can probate be avoided? Get a will, number one, because remember, if you have a will, you appoint the person who is going to act for you. You don't have to go to court to have an estate trustee appointed. Number two, consider the type of assets that will be in the estate. Those that are jointly owned or designated beneficiaries, typically, you will not include in the estate for probate purposes. Does the nature of property holding require probate? So if you own a house and you're the last owner, there's no joint owner of that house. It may well be that under the Land Titles Act in Ontario, which is our major legislation, not only one, you may have to have a certificate of appointment of a state trustee issued in order to convey, to sell the home. Couple of important items here. Number one, ask the institution you deal with about probate requirements, about dollar thresholds and indemnity agreements. And I already touched on that. But if you've got an investment advisor or your bank, you can speak to them about, hey, at what point do you require probate in the event of the death of an individual? So you're better off, you have a better understanding. You can also, and I didn't put this point down here, but there are certain kinds of properties that don't require probate. Shares in small companies, for example, small business corporations don't require probate in most instances. So quite often lawyers or tax advisors and so on will recommend doing what are called primary and secondary wills. But again, that's a matter that you should seek advice on. What it does is that it puts into the secondary will items that may not be subject to probate, so that you don't have to worry about waiting. The primary will is the one that gets probated. And then lastly, again, you'll see the capitals here, get good tax and legal advice. You can ask your advisors about trusts to hold assets, or a trust agreement if you're going to put your assets into joint names with other parties. So please don't run out and put the house and the bank accounts and everything else you own in joint names. It does trigger a tax, but more importantly than that, it can create a real mess in families as to whether doing so was intended to give a gift to somebody or was just a convenient way to try to avoid probate taxes.